Ever stare down a legal case scenario question, maybe for an exam or just trying to understand a real world problem and think, where do I even begin?
Oh, absolutely. It can feel pretty overwhelming, right? You've got all these facts, bits of law, and you need to somehow weave them together logically.
Exactly. And that's precisely what we're diving into today. We've pulled together some great materials, actually, including a guide designed specifically for tackling these kinds of problem questions, plus some foundational notes on contract law, all focused on, well, a really interesting concept: duress.
Yeah, think of this as a practical toolkit session. We're going to use a specific scenario, kind of walk through it to show you how to unpack the legal puzzle and apply the right principles, step by step.
Consider it your shortcut to not just knowing the law, but really mastering how to use it when it counts. So let's jump in. When you think about contracts, usually it's like offer, acceptance, consideration, bam, binding agreement.
Seems straightforward enough.
But our sources talk about things that can come along and, well, mess all that up. Factors that can undermine a contract even after it looks perfectly formed on paper.
These are what the law calls vitiating factors.
Mhm.
The materials describe them as things that can impair or make void or voidable. Basically, they annul a contract's legal power. They stop it from being fully effective.
They sort of taint the agreement, yeah.
Exactly. And there's a whole bunch of them: misrepresentation, mistake, undue influence. But today, we're really zeroing in on just one: duress.
Duress. Okay. What does that mean legally? It's not just feeling pressured, is it?
No, not at all. It's a common law idea, and it's specifically about pressure used to coerce someone, to force them into doing something. The law is really concerned with pressure that's so significant that it would cause a reasonable person to act in a way they wouldn't normally choose to.
So, like, my boss yelling about a deadline probably doesn't count.
Probably not, no. Unless the threat is, truly illegitimate. The materials make this really crucial distinction. Under duress, the victim's will is deflected, not destroyed.
Deflected, not destroyed. Okay, that sounds important. What does that actually mean in practice?
It means the person under pressure still technically makes a choice. They choose to give in to the demand rather than face the threatened alternative.
Yeah.
The issue isn't that they physically couldn't refuse, it's that the illegitimate pressure left them with no realistic or reasonable alternative path. Their choice wasn't truly free.
Got it. So it's about illegitimate pressure, pressure that's just not okay, leaving someone feeling backed into a corner with no real way out except to agree. Now, our sources also talk specifically about a type of duress that comes up a lot in business: economic duress.
Right. This is where the threat isn't physical, like the old cases, but it targets someone's financial interests or their business survival. It's about agreeing to a contract or often like agreeing to change an existing contract because of threats to your economic well-being.
Like a supplier threatening to withhold vital materials unless you agree to pay more, or a big client threatening to pull a massive contract.
It's exactly that kind of thing. It often involves one party threatening to break their side of the deal or withhold something they're supposed to provide unless they get, say, an extra payment or, like in the scenario we're about to look at, a price reduction. It essentially exploits economic vulnerability.
Okay, this is where it gets interesting. Let's apply this. Our materials have this case study about Liam, who runs Creative Designs Limited, and his client, Big Corp PLC.
Yeah, this is a classic setup. You see variations of this all the time. So Liam has this contract with Big Corp PLC worth $50,000. And the materials really stress this point. This single contract makes up 80% of his company's income.
80%. Wow, that immediately tells you he's in a vulnerable spot financially.
Definitely. So the deadline for the project is getting close, just 2 weeks away, and suddenly Big Corp's project manager, Mr. Henderson, drops a bombshell. He demands Liam cut the price from $50,000 down to $40,000.
Just like that, out of the blue.
Pretty much. And it's not a request. It's a demand with a clear threat attached. Agree to the lower price now, or Big Corp will terminate the contract immediately and just hire someone else to finish it.
And crucially, the scenario adds that Henderson knows terminating the contract at this stage would probably bankrupt Liam's business.
Right. That knowledge makes the threat seem much more calculated and, well, illegitimate. It's not just tough negotiation. It feels like exploitation of Liam's known weakness.
So Liam's obviously under huge pressure. What does he do? Does he just roll over?
No, not initially. The facts say he protests strongly. He points out, the work's nearly done, they had a deal. But when he looks at the reality of the situation, he sees no realistic alternative way to quickly find replacement income.
He's trapped.
Essentially, yes. Fearing the total collapse of his business, he feels he has absolutely no choice but to agree. And this is key. He agrees in writing, but he adds a note. He writes, under protest due to unforeseen circumstances.
Ah, under protest. That sounds like something a lawyer would tell you to do.
Certainly a very important piece of evidence. So he finishes the work. Big Corp pays the reduced amount, $40,000. And now Liam wants that missing $10,000. The big question the guide poses is, can he legally claim it? Can he argue that his agreement to take less money isn't binding because of duress?
Okay. And this is where the guide brings in that structured approach you mentioned, IRA.
Exactly. IRE. Issue, rule, application, conclusions. The standard framework really useful for making sure you cover all the bases in a logical way when analyzing a legal problem.
Right. So let's apply IRAX to Liam's situation. First up, the issue. What's the core legal question here?
Well, the main issue is whether Liam's agreement to accept the lower price of $40,000 is actually legally binding, or, put another way, was that agreement forced on him by economic duress? And if it was, what happens then? Can he successfully challenge that variation to the contract?
Okay, that's the puzzle. Now for Are the Rules. What legal principles do we need to bring in to solve this?
We need to start with the basics, the definition of duress itself, and specifically economic duress. So we're talking about that illegitimate pressure, coercion, threats to economic interests, the whole idea that the will is deflected because there's no practical alternative.
And the materials mentioned a specific case, Citibank, with some key factors.
That's right, Citibank NAV Lim Supang. It's a Singaporean case, but often cited for its helpful checklist for economic duress. The court looks at four main things.
Okay, what are they?
1. Did the victim protest when the pressure was applied? 2. Did the victim have any realistic alternative course open to them, other than just giving in? 3. Did the victim get independent advice before agreeing? And 4. After agreeing, did the victim take steps to avoid the contract or challenge it?
Those seem like really practical questions. They help separate genuine pressure from just, a bad deal.
They do. They focus on the victim's conduct and their actual options. We also need to state the effect of duress. The materials are clear. A contract made under duress isn't automatically void from the start. It's voidable.
Voidable, meaning Liam, the innocent party, gets to choose. He can choose to rescind it, to set it aside.
Correct. It stands unless and until he takes action. But, and this is a big but, you can lose that right to rescind. The materials mention this, referencing cases like North Ocean Shipping. If you wait too long, or if you act in a way that suggests you've accepted the new deal, despite the duress that's called affirmation, then you might be stuck with it.
So timing matters. You can't just sit on your hands.
Definitely not. And one more thing for the rules section. The guide mentions Atlas Express Ltd v. Kafko Ltd. That seems pretty relevant too, doesn't it?
Yeah, tell us about that one quickly.
In Atlas Express, a delivery company basically told a small basketware company, pay us more than we agreed or we won't deliver your goods to Woolworths, knowing the small company absolutely depended on that delivery happening and couldn't find anyone else last minute. The court said, yep, that's economic duress.
Sounds very similar to Big Corp leaning on Liam.
It does. It's a good case to cite as a parallel.
Mm-hmm.
Okay, so we have the issue, we have the rules definitions, the Citibank factors, voidability, the risk of affirmation, and a relevant case. And now for the A application, we apply these rules to Liam's specific facts.
Right, let's connect the law to what actually happened to Liam. First, the pressure itself. Big Corp's threat.
Oh, it's pretty significant, doesn't it? Threatening to terminate a contract that's 80% of Liam's business just 2 weeks from completion, knowing it could bankrupt him. That feels like more than just commercial hardball.
Yeah, it smells like illegitimate pressure targeting his known vulnerability. And the facts say Liam felt he had no choice. That speaks to coercion.
Definitely. Now, let's systematically go through those Citibank factors for Liam. Factor 1, did he protest?
Yes. The facts are explicit. He protests strongly. And even better, he wrote under protest on the agreement itself. That seems like pretty strong evidence against voluntary agreement.
Absolutely. It's a clear signal, recorded at the time, that he wasn't happy and felt forced. Okay, factor 2. Did Liam have a realistic alternative?
The scenario says, no realistic alternative way to quickly find replacement income, and he feared the collapse of his business.
That's crucial. The law doesn't require someone to commit commercial suicide to prove duress. If submitting was the only practical way to avoid ruin, it strongly suggests his will was overborne. Lack of alternatives is key.
Okay. Factor 3, independent advice.
The facts don't mention any. We don't know for sure, but the absence of any mention suggests he probably didn't get legal advice before caving in. This can sometimes strengthen the duress claim, showing he might not have fully understood his options.
Makes sense. And a final factor, number 4. Did Liam take steps afterwards to avoid the agreement?
Yes, the fact that he's now trying to claim the outstanding $10,000 is that step. He's challenging the variation. The guide makes a good point here. His immediate protest at the time, combined with his later action, argues against defamation. He didn't just accept the lower payment and stay quiet.
Right, unlike that North Ocean shipping case where they waited months, Liam's actions seem much more consistent with someone who felt wronged from the start.
Exactly. And bringing back the Atlas Express parallel, it really fits. A powerful party using its position to force a change mid-contract, knowing the other side is dependent. It looks very similar.
Okay, so we've worked through the application, we've connected the rules to Liam's situation using those factors. That brings us to the final step in IRS. See the conclusion. What's the likely outcome for Liam?
Well, putting it all together, the nature of the threat, Liam's clear protest, his documented lack of realistic alternatives, the probable lack of advice, and his action to recover the money, it seems highly likely that a court would find the agreement to reduce the price was obtained through economic duress.
And if it was economic duress?
Then the variation agreement is voidable by Liam. Since he protested immediately and took steps to challenge it reasonably promptly by seeking the balance, he likely hasn't lost his right to rescind through affirmation or delay.
So the bottom line.
The bottom line is that Liam should have a very strong case. He can likely argue successfully that the $40,000 agreement isn't binding because of duress, and he should be able to recover the remaining $10,000 from Big Corp PLC. The IRSC method helped us get there systematically.
And you can see how using that structure issue, rule, application, conclusion really helps organize your thoughts and build a logical argument when you're faced with one of these problem questions.
Absolutely. It's not just an academic exercise. It forces you to identify the real question,
Yeah.
state the relevant law clearly, apply carefully to the specific facts you're given, and then reach a reasoned conclusion based on that application. It stops you from just jumping to an answer.
And this whole discussion about duress, especially economic duress, is a great reminder that contract law isn't just about signatures on paper. It cares about whether the agreement was entered into freely, without unacceptable pressure messing things up.
Which leaves us with a fascinating question to think about, doesn't it? Where exactly is the line between tough, maybe even ruthless negotiation, which the law generally allows in commerce, and illegitimate economic pressure that amounts to duress? How do courts balance protecting vulnerable parties with the need for certainty in commercial deals?
Definitely something to chew on. Where does hard bargaining end and coercion begin? A tricky line to draw. Until next time, happy deep diving.